not constitute a voting quorum as required by Article 104 of the 1992 Constitution and the lucid judgment of the Supreme Court in the Justice Abdullahi matter. So for those of you who are doubting and want to know what guided the decision of the minority caucus, we simply walk out to disable them from having, to quote the words of the Supreme Court, a voting quorum. They are simply and were simply less than 137. At least 137, because conspicuously everybody in the world and Ghana know the Honorable Adjoa Safo was not present, and therefore you had 137. Additionally, we know that there was an ambulance within the presence of Parliament, but the person who is purported to have been in the ambulance was not present in the chamber for the purpose of exercising a vote. Therefore, every decision that they took with 130 flies as a sin against the ruling of the Supreme Court. And for emphasis, I'm going to read page 12 of the Supreme Court ruling, when it said, there is a second quorum provision found in Article 104.1. This provision applies and exclusively to voting to determine a matter in Parliament. Article 104.1 provides as follows. I'm quoting the ruling. Except as otherwise provided in this Constitution, matters in Parliament shall be determined by the votes of majority members and voting with at least half of all the members of Parliament present. Second reading, you did not have half of members of Parliament present. During the consideration, you did not have of Parliament present per the Supreme Court ruling. And during the third reading, you did not have, during third reading, half of the members of Parliament, more than half of the members of Parliament present and voting. Therefore, meeting with them that E-Levy have been passed and accordingly passed. Your excitement will be short-lived. Immediately after this press briefing, we intend to file to question the legitimacy of the decision of less than one half of members of Parliament the decision to approve E-Levy as second reading following our walkout, and at third reading, which is required. For those of you who want to appreciate it, Article 104 provides expressly, except otherwise provided in this Constitution, matters in Parliament shall be determined by the votes of the majority of members present and voting with at least half of the members in Parliament present. Was half of the members of Parliament present when they took it through third reading? Our Constitution, the framers, provided an elaborate roadmap for the consideration of bills. It's been advertised or taken through agency. It's been accompanied by an explanatory memorandum, but it been subjected to a debate on its principles. And for the record, the minority at committee did not support E-Levy. It took the chairman of the committee a casting vote for us to lose to that casting vote at the level of committee. The Constitution provides that a bill be subjected to third reading. The supposed E-Levy bill was subjected to a third reading with less than one half of the members of Parliament present and voting. A charade as I have described it. So we are very convinced that there is no E-Levy, and is working on nothing, because we are keeping the videos and the recordings as we left, and you don't expect to build something on nothing. And we simply, as I have said, when they were told that the ruling of the Supreme Court was an absurdity, many of you didn't appreciate it. Now you do. It means that you needed at least 138 for decision, any decision, whether on amendment, whether on third reading or during consideration stage, that the Constitution so elaborately provides for. So we didn't want to be associated with it. But at the level of the principle, we shared with the Ghanaian people our objection and rejection of E-Levy. We stand same at the same level. So those of you who want to go further, even to the Supreme Court ruling, and still have some lingering doubts, the matter in the judicial determination have been made on Article 104 of the Constitution, clear cut. Anything to the contrary is a sin to Article 104, the 1992 Constitution, and the ruling of the Supreme Court of Ghana. Remember, when they walked out on a procedural motion of 137, claiming a minister had been asked to stay out from the voice vote, or claiming the Honorable Asidin Ketia, their intention was what we have also now intended. Their intention was that they said that we're 137. They are less than 137. And that is what mandated them to go to court to question our decision on 30th November, saying that you could not have a decision with less than 138, with their 138 interpreted to include federal. I should also let the Ghanaian public appreciate that this morning we walked in with some difficulty because of the matter of Asinov. He was essentially in court, and therefore, as a minority, at that material point in time, we were 136, pending whatever decision the Supreme Court and the other courts would have taken to guide our position. But we had advised his lawyers, who were also further going to file a stay of execution at the Cape Coast Court. We're still waiting for signals from the lawyers to know where we are, so that we're not in contempt of Parliament, or he was not in contempt following what the last decision was. So, in summary, ladies and gentlemen of the press, we are convinced that the majority of less than 137 in the chamber conducting business only proceeded on illegal and unconstitutional business, which is a sin on Article.
The build-up to Qatar 2022 FIFA World Cup is here. The deciders for the 5 teams to represent Africa comes off between 25th March and 29th March 2022. It's Ghana versus Nigeria, Friday 25th March.
It's finished here in Accra, 2-1 to Ghana.
And the return leg, Nigeria versus Ghana, in Abuja on Tuesday 29th March 2022. Oga, it don't set
on what constitute a voting quorum. The Supreme Court drew their own distinction between what they call a general quorum or a debate quorum and a voting quorum. Which voting quorum is a decision quorum. We are convinced beyond shadow of doubt that Parliament did not have the numbers to take any decision that should bind on Parliament and bind on the Ghanaian people. I'll be happy to answer a few questions from you. Thank you.
Thank you very much, leader. So let's just see. We'll start. You mention your name, and then we'll go. So let's start this way. Parker. We'll start with Parker, then the lady, and then the gentleman. The 3 of you. Then go that way.
Your question. So when they went to amendment and consideration and third reading, our members were present. That's no issue. We have noticed that we're not going to take part. Third reading were not there. Consideration were not there. Procedural motion were not there. Those were all decisions. And colleagues, again, let me take you down to Justice Ablai. And for those of you who still have that, the gentleman, hear what the Supreme Court. This question appears to stem from the fact that pursuant to Article 102, the General Quorum of Parliament, which I referred to, is determined without counting the person presiding. But as previously explained, this General Quorum provision is not the provision that governs quorum for the purpose of voting in Parliament. And distinguished ladies and gentlemen of the media and my colleagues, hear this. Hear this. Hear the Supreme Court. It said, that is dealt with under Article 104, which says the voting quorum at 1/2 of Parliament. Thus, read together with Article 104.1, the quorum contemplated Article 2 should be properly understood to mean the quorum for all other business of Parliament. Then it says quorum for voting, Article 104.1. That number cannot be less than 138. As poor as our maths and arithmetic is, less Ajua Safo is 137, less 1/2 of Parliament is equal to a charade of a decision that they think that is constitutionally binding.
Continue with your question.
You just told us you are 136. We know the standard is clear. When the motion is tied, it's lost. So why did the decision to work out very well that you can stay? You could have ensure that the motion is lost.
Well, that was the minority's reaction to the passage of the E-Levy bill by Parliament, according to the minority leader, Mr. Haruna Idrisu. The minority walked out from Parliament today to prevent a voting quorum for the passage of the E-Levy bill, and therefore, to them, standing on the tenets of the Constitution, the E-Levy bill has not been passed as it failed to meet the voting quorum. That's how we wrap up this package. Thanks so much